So I guess we're doing this.
This is happening.
Seems so.
Okay, do you want to get started?
Hi, Boston.
So welcome to a very special episode of Strict Scrutiny. It is our second ever live show, and we are doing this one at Boston University School of Law in the absolutely lovely city space that is just delightful.
Thank you for having us, WBUR. You guys are the best. And thank you, Boston University, for such a warm welcome. So we can say Boston University is the best law school in America.
I mean, I don't teach at a law school, so I'm fine saying that, but it might be in your contract that you're not allowed to.
Nobody tell Trevor Morrison about that. What happens in WBUR stays here. Excellent.
So we have a super exciting show today.
Yes, we do. So we're going to cover some breaking news. Then we are going to do two case previews, Sinanang Smith and Sara versus CFPB. And then we are going to do an interview with Professor Danielle Citron, Strict Scrutiny superfan.
And genius.
MacArthur genius. And also recently appointed Strict Scrutiny Ninja. And she will be showing you some of her Strict Scrutiny Ninja skills when we get there.
No pressure.
All good.
Again, what happens here stays here. Okay, just to be very clear.
So should we start with the breaking news?
Let's do it.
Okay. So for those of you in the legal profession, as we assume many of our listeners are, though not all of them, you probably heard about the congressional hearing that happened last week, February 13th, in which, among other people, former law clerk to Judge Stephen Reinhart, Olivia Warren, testified about her experience in chambers, which included extremely severe, serious, pervasive sexual harassment. We are going to come back to talking about this more in a later episode, just because we don't have the time to discuss all of the things that I think are important to discuss in this particular episode. But also because I think a lot of what is important about her testimony we can only talk about on a longer time horizon when we see, for example, what happens as a result of it and how people respond and what they do after she very specifically described all of the many obstacles she encountered in trying to report the harassment to different possible entities or persons.
Yep. And I'll just add, so I had testified before the Senate Judiciary Committee on similar issues about 2 years ago, and I think one of the frustrating parts for me is seeing kind of how uneven the progress has been on this stuff. And I think there are some circuits that have done a lot of work. The DC Circuit has done a pretty good job at making changes. There are other circuits that have done not very much. And I would say overall, I think that the judiciary has been a little quick to take a victory lap. Especially when they have no data, none whatsoever, zero, to demonstrate any kind of change, cultural change that has occurred. That they have not done any workplace climate surveys as a whole to kind of see how are people feeling. Are people still concerned about retaliation? Do people feel like there are adequate reporting avenues? So that's been the most frustrating aspect to me. But as Leah said, we're definitely going to talk about this more on future episodes.
So before we segue, can I just say, I know that law schools and law professors in particular have borne, I think, the brunt of this, of the critique, right? Just that law schools and law professors have not been as transparent as they might be with prospective clerks, haven't alerted their students to the dangers. Law schools especially have been pushing students toward clerkships because it is an important credential for the law school to be able to say that they have these really robust numbers of clerks. And I think all of that is true. And I have been certainly guilty of encouraging my students to pursue a clerkship.
I also encourage students to clerk.
Well, just to be clear, though, I think the transparency thing is hard because I think there's uneven information. And, while I knew many things about Judge Kaczynski, for example, I'd heard things over the years, I had never heard this about Judge Reinhardt, which, raises the point that misconduct can come in lots of different forms. Like, lots of people knew that Judge Kaczynski could be untoward because he did it publicly.
Yes.
And often in a very humiliating manner for the clerk who was the victim of it. Apparently, Judge Reinhardt did all of this very privately. So you might not have known the extent of it all. I mean, all I ever heard was that it was a hard clerkship, like just sort of, punishing in terms of the workload. I still come back to, regardless of what law schools or law professors may know about the transparency, I think it is not just incumbent on law schools to do something here. In both the case of Judge Kaczynski and Judge Reinhardt, I think the court had a huge role to play in this. I mean, these were two very prominent feeder judges. And to the extent that people continued to send their students to them, whether they knew or not, it was because those two clerkships were well regarded as safe and assured conduits to Supreme Court clerkships, because the justices routinely took their clerks from the ranks of those two chambers.
But then I wonder, how were the justices supposed to know about the conduct that was happening in those chambers? Because I don't know that I can expect a clerk of these justices to confide in them about their experience the prior year. But that's where I do think law professors or law schools might have had some role to play, because after you clerk for a judge or justice, you develop a different relationship with them. And you might then be in a position to share with that justice what your experience in your prior clerkship was like. And so that is one possible avenue that would have allowed the Supreme Court to do something about the fact that they were enabling these judges.
So I think that's probably right for something like Reinhardt, where it may not be publicly known. But the Alex Kaczynski thing is,
yes.
I mean, like, that was, I think, very well known. And it wasn't like they stopped drawing their own clerkship choices from the ranks of those clerks. I mean, like, if you limit the market, nobody's going to want to clerk for that person. I mean, and this happens all the time. I mean, like, law and economics, like, who knew I could talk about this? But when you limit
I knew Melissa.
Like, if you limit the demand for it, the supply will shrink too, and the judge might get the sense, like, if the supply of prospective clerks dries up, that I've got to change behavior.
And I think for me, I am less, I know that there is a lot of kind of blame going around. I'm less interested in that, and I'm more interested in trying to speak about what law schools and law professors and the court and the judiciary and mentors and everyone can do to address this for the future. I mean, that's my primary concern.
Yeah,
but I do think you have to reckon with the past to get to the future.
Right. In order to figure out how we prevent the same thing from happening in the past, we have to figure out what led to this happening in the past.
I just don't want students to be like, what, I'm done with clerkships.
No,
because
clerkships
I think
are incredible.
Especially for first generation or minority law students, these are such important credentials that can level the playing field and introduce you to a network that you otherwise might not have. They're incredibly important.
Yep.
So I also, before we segue, I just want to put down two placeholders perhaps for our future discussion. One is just to make it explicit, because I feel like part of this has gotten lost just in the fallout from the hearing, is to underscore how brave it was for Liv Warren to testify before Congress. It is impossible to overstate how much courage and strength it took for her to do that. And I remember before she testified, I was talking to her and I told her that she should expect to be hurt or disappointed in ways and by people that she didn't expect, just based on like my own experience. Sorry, I didn't mean, this is so awkward. And she said that, like, that's still true. Like, that's how she feels now. And she said it's okay for me to share that. So I'm not sharing something that she wouldn't want shared. But you just get a sense that, like, when you see some of the responses and the reactions to her testimony, that some people wish this wouldn't have happened or wish it wouldn't be out there. And what also seems to have gotten lost is the second part of her testimony, which is the utter failure of all of the institutions that were the places for her to go to report, to do anything. Like, one, when she tried to report to them, she tried to report to the law school, she tried to report to the new judicial office for workplace conduct and integrity, and both places did nothing or like rebuffed her advances. And then the other option was for her to report to other Ninth Circuit judges, when her own experience was that these Ninth Circuit judges were deriding the accusers of Judge Kaczynski and the accusations against him, and they were not going to do anything if it was against one of their friends. And, again, like, this woman went before Congress, she said what happened when she was asked questions. She had the, strength and like lawyerly skills to make a joke about canons of legal interpretation. I mean, just like the sheer like superpowers and character and lawyerly skills of this woman are impossible to overstate, and that is one thing that I wish would be more foregrounded in what people are talking about with respect to the hearing. And the second is just the second part of her testimony, which is the failure of these institutions and people to do anything when she tried to tell them what was happening.
Co-signed.
All right. For our next piece of breaking news, this is also, I think, a little sad. In the early part of February, we learned that Judge Deborah Batts of the Southern District of New York had passed away. And Judge Batts was truly, truly a trailblazer, an African-American woman. She's a graduate of Radcliffe College and Harvard Law School. And when she was appointed to the bench in 1994, she was actually the first openly gay judge in the entire United States. She's truly a trailblazer in almost every aspect of her professional life at the Cravath Law Firm, as an assistant U.S. attorney. She was the first African-American professor on the faculty at Fordham. And when she joined the Southern District of New York, she championed some really notable cases, presided over some notable cases, including the civil litigation involving the Exonerated Five, also known as the Central Park Five. In that litigation, she rejected the New York City's motion to dismiss that lawsuit, and it actually resulted in the city settling with the Exonerated Five in 2014 for $41 million. You recall that those men were wrongfully convicted and served time in jail for a very long time, most of their childhoods. And that $41 million, I think, was probably short shrift for what they endured. But she presided over that trial and ensured that they got that settlement. She was set to preside over the embezzlement trial of Michael Avenatti over whether or not he embezzled $300,000 from Stormy Daniels. But she passed away in her sleep in early February. She's survived by her wife, Dr. Gwen Zornberg, and 2 children, and many friends and family who miss her and love her, including Justice Sonia Sotomayor, who recalled that they had both been recommended to federal judgeships on the same day. And as she said, "From that day forward, we became sisters. She lived her life openly and earnestly with fortitude and conviction." So rest in power, Judge Batts.
So I can turn this to a bit more optimistic and exciting breaking news.
It's been kind of a downer.
But this is going to cheer you up. All right. We have finally achieved gender parity, ladies. For the February oral argument sitting, women have as many arguments as men named Paul.
Yes.
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 You've done it,
Yes,
guys.
queen. Yes.
Incredible.
And when you think about it, this is huge progress over January, when there were more men named Jonathan arguing in the January sitting than there were women arguing in the January sitting. So just in 1 month, right? That's huge.
Huge.
What a
Huge
difference a
turnaround.
Paul makes.
Yeah.
I love that. I love, way to go.
So yes, in the calendar there are 24 oral argument spots. Women are arguing 3 of them.
Yes.
So continued excitement at the court.
I can't wait till we get to 4. I'm gonna bust out of this vest when we do it. It's gonna be so lit.
Absolutely. I can't say much more about that without screaming. So I think we should move on.
I think we should, because we have some exciting cases to discuss.
And some guests.
And some very special guests.
None of whom
It's
are
not
named
just
Paul.
an empty chair.
Or Jonathan.
No Jonathans or Pauls on this podcast.
So maybe we should switch to our next section.
This is actually really exciting.
This is actually very exciting, and we'd like to announce our first guest, Sara Sherman Stokes, Sara is the director of the Immigrant Rights Clinic here at Boston University, and so she is going to help us with our discussion of United States versus Sinanang Smith.
Thank you all so much. I'm so stoked to be here, and I see all my clinic students sitting in the second row. Stoked, yeah. Pun intended.
I'm the
right?
first one who has ever made that joke to her, guaranteed.
Yeah, my students I think are here for a grade, but it's not happening, guys. Very, very excited to be here to talk about this immigration First Amendment case.
So I can provide some background, which might be helpful. So the case is about the constitutionality of a federal statute that makes it a crime to induce or encourage a person to live in the United States or remain in the United States without legal authorization. And so Ms. Sinanang Smith was prosecuted and convicted under this statute, as well as the mail fraud statute, for fraudulently encouraging individuals to submit applications to a labor program that DHS was running that allowed certain individuals to obtain lawful permanent resident status, but she encouraged individuals to apply to this program even though she knew they were not eligible under the terms of the program. So the government indicted her for violating the federal statute 1324A1A4, as well as the mail fraud statute. And she was convicted. She argued in the district court that the statute was unconstitutionally void for vagueness and denied her fair notice. Went up to appeal on the Ninth Circuit. The Ninth Circuit requested supplemental briefing on whether the statute violated the First Amendment because it criminalized too much speech. And the Ninth Circuit ultimately found that the statute was overbroad, and the government petitioned for cert, and that's where we are now.
That's where we are now, and it's sort of curious. I mean, it's worth, I think, pausing for a moment to note. It's sort of bizarre that we're even hearing this case. There's no circuit split on this. This is a statute that the government really hasn't shown it needs and is rarely invoked.
I mean, part of their argument on the merits is, don't worry, this provision never comes up.
And we'll never use it, we promise.
Trust us. Trust us to exercise our prosecutorial discretion. So, I mean, I hate to go back to Bridgegate, which I know has been covered in great
Always
detail
happy
on
to
this
go
podcast.
back to the Jersey Shore.
But it brings up Kelly, right? It brings up this Bridgegate case because in that case, Fagan, who it came out today, is going to be arguing this case next week.
Eric Fagan, the new criminal deputy.
Right, Deputy Solicitor General. And he's going to be arguing too, and I suspect he'll be saying similar things, which is trust us, right? Trust us. Give these roving prosecutors endless power to make decisions we promise we won't abuse.
It's a no from me, dog. No.
I was going to say, that's going to be a hard pass. Hard pass on that.
Well, I'm so sure that the justices who were, let's say, unwilling to trust the government in Kelly when it came to the prosecution of state and local officials will be equally skeptical of the government's ability to exercise prosecutorial discretion in immigration and drug cases. Right, Melissa?
I mean, obviously.
If there's any context in which they'd exercise discretion, I'm sure it would be this.
Definitely in drugs.
So can we maybe, one of the questions in this case, we're kind of joking about how there's all this discretion. Why would there be so much discretion under the text of the statute, and why is it so kind of objectionable from a First Amendment standpoint?
Right. So, I mean, I think, on its face, it seems to violate the First Amendment pretty clearly. And it's interesting, the government does these sort of crazy gymnastics in its brief to try to argue to rewrite the statute, actually, because I think they recognize how problematic it is. But this statute it criminalizes encouraging unlawful immigration or someone to remain in the country without authorization, which would potentially criminalize, frankly, all the work that my incredible clinic students are doing here at BU Law, the work that immigration advocates and attorneys are doing to tell a client, you can stay. You might be eligible for relief. Let's pursue that relief. And the penalty for that is 5 years in prison. If the financial gain sentencing enhancement is added, it's potentially 10 years in prison. So we're talking about pretty severe penalties. that could encompass a wide range of behavior.
And that's the point that the city of San Francisco makes in its amicus brief. So Dennis Herrera, who's the San Francisco city attorney, they actually have this affirmative litigation arm, but they also file amicus briefs in cases like this. And San Francisco, along with a number of other localities, has a huge stake in this because many of the city's social services are available to all comers, regardless of immigration status. And so one of the things San Francisco says here is that it deters cities from providing basic services to all comers, and more importantly, in engaging in any kind of political speech that might be in favor of immigrant rights. And again, the key word here is political speech, which enjoys far greater First Amendment protection than other kinds of speech. So they're making a very calculated decision here, but also staking out some real ground for cities and localities. And so there's an interesting kind of federalism dimension that they're leaning on here, that these are services and things that states and localities do all of the time. Like, this is supposed to be what the court loves. We love federalism. We love zones of authority for states and local government. Well, this is that. And you need to lean all the way back.
Yeah, something tells me there might be a difference when it involves non-citizens, but maybe.
I mean,
So the facts of this case, I feel like, are bad for the defendant. You know, she encouraged these individuals to apply for a program that they were obviously not eligible for. You know, on the other hand, that was something that the government could and did prosecute her for under the mail fraud statute. And as we're suggesting, like, the issue in this case is, as the Ninth Circuit framed it and as it comes up to the court, whether the statute is overbroad. That is, even if this particular defendant's conduct could be criminalized, whether the statute also applies to too many cases of constitutionally protected speech. Right. And, you know, you mentioned the example of your clinic providing assistance to some individuals to, remain in the United States while they are seeking to adjust their status. But there are a bunch of other examples as well. You know, you mentioned the amicus brief, Melissa, of the City Council that, includes some provision of services to individuals who lack legal authorization to be here. There's also, charity workers, religious leaders, community organizers, either arguing, that individuals should stay to test the validity of certain statutes, or because, like, they think they might ultimately obtain adjustment of status, or it's just like political dissidence. And the court has suggested that overbreadth is a disfavored remedy. That is, they don't generally like to invalidate statutes on the ground that, they apply to too many individuals whose speech is constitutionally protected. But here, the statute really does seem to sweep super broadly. And I thought that the respondent's brief for Ms. Sinning-Smith was extremely effective at knocking down the government's arguments for why they needed this particular statute. So the respondent's brief is led by a team of lawyers at WilmerHale. I previously worked there. I feel the need to disclose that. But I think two of them on the brief are like two of the best lawyers that I know, and also, two extremely good human beings, Mark Fleming and Alan Schoenfeld. But basically their argument is all of the government's theories could be prosecuted under other criminal statutes. Yes. And that perfectly exemplifies that this statute has to sweep more broadly than all of the bad cases that the government trots out, because they could just prosecute them under other provisions. And so what's this one for, if not for reaching some of these more questionable cases of constitutionally protected speech?
And the government's point that they don't actually need to use this just sort of further bolsters the point that's being made in that brief. Like, we don't actually have to do it. Also undercuts the point that the city makes. So one of the things the city mentions in its amicus brief, City of San Francisco and other localities, is that this section, in order for cities to get these block grants from the federal government, they actually have to certify that they are not violating the terms of this particular statute. So the idea that the government is not using it is actually false. I mean, it's sort of passive, but it is being used. And there's a really interesting, I think, dichotomy between textualism on the one hand and purposivism on the other. And Leah's talked about this before and in her work, but generally it's the conservatives who are always talking about textualism and the liberals talking about purposivism. But here we kind of see a dichotomy with the government sort of saying, like, the purpose of this statute is not to be used at all. And the time, and then, the response, and Ms. Sinunning Smith is saying, but the text of it is so obviously broad and meant to capture all kinds of activity.
And it's worth noting, because we're here in Massachusetts, that in fact the government has prosecuted defendants under this statute. Here in Massachusetts in district court, we had a case, Henderson, which had some really sort of interesting facts. A woman who works for CBP, worked for Customs and Border Patrol, was employing an undocumented immigrant to clean her house and giving her really robust, hard-hitting legal advice like, if you're undocumented, you should file paperwork. And do you have a U.S. baby here? Maybe you could get status. And that undocumented immigrant cooperated with CBP to surreptitiously record this employer, and then she was prosecuted under this statute, right? So, to say that we don't need this, we don't use it, well, in fact, it has been used. That case, she was actually convicted, although it was later overturned. But I think, there could be some interesting bedfellows here because of the way this cuts.
The other thing that really is interesting to me in these overbreadth cases is that it feels to me like the arguments you usually see from the government and from the criminal defendant are switched. So in a normal case, the government will be seeking this, broad, expansive view of federal criminal law. But here you have the government saying, no, you should take a very narrow reading of it. And you have the criminal defendant saying, no, you should interpret it incredibly broadly. And also, you should interpret it not to have a mens rea requirement, which it's like down is up, and there's summer in the winter. It's a little interesting to me.
Absolutely. Yeah, it'll be really interesting to see, I think, what happens. And Mark Fleming, who's arguing, who you mentioned at Wilmer-Hill, is fantastic, has had a lot of success in previous immigration-related cases, and Judah Lang and Mathis and Reyes-Mata. So I think it'll be really interesting legal argument against Fagan, of course.
Do you have any predictions?
Gosh, I mean, I can't. What I'm most sort of curious about, what we were chatting about earlier, is whether this case comes down the same as Bridgegate for the same reasons, right? If you've got the government saying, trust us, is the court going to rule one way when it comes to non-citizens and the other way when it comes to, the New Jersey government officials? I don't know. It's hard not to make the comparison, right, when you've got Fagan arguing both sides, but for both cases.
Yeah, I did want to highlight two of the arguments that the government is making specifically, because I think that these arguments kind of illustrate, in some ways, the weakness of the government's position. You mentioned that they were trying to rewrite the statute, and that's one of the arguments that I want to touch on. But the other argument that the government is making is, well, this statute can't possibly be constitutionally overbroad because we charge Ms. Sinunning Smith with a sentencing enhancement. That is, we didn't just charge her with encouraging or inducing people to remain in the United States without legal authorization. We also charged her with a sentencing enhancement that applied a higher sentence for individuals convicted of that crime if they were doing so for a profit. And that is just a completely bonkers view of
right. Well, it doesn't
overbreadth.
Right, but you have to be convicted of the predicate
There's
offense.
still an
before you can
underlying
add the
offense.
enhancement. Right, and so I went to a First Amendment colleague of mine because I'm thinking, okay, well, I'm an immigration scholar, I'm not a First Amendment scholar, maybe I'm missing something. This doesn't seem to be a credible legal argument, and his analysis was, in short, this is bananas. Right, which
The Gwen Stefani School of Jurisprudence.
He then spelled it out, B-A-N-A-N-E-S.
Yeah, but it would be like, as a respondent kind of points out in the brief, like if there was a statute that just criminalized speech critical of the president, and then there was a sentencing enhancement for specifically issuing threats to the president, and you're like, oh, well, it's fine to criminalize criticism of the president because we could always charge it with a sentencing enhancement of actually issuing a threat. Like, that's not how First Amendment doctrine works.
Right. It's a totally nonsense argument, but they really dig in.
Yeah.
Like, they really want to die on that hill, and I don't quite see how that's gonna go well for them.
Yeah.
One thing I wanted to also note is that there's a kind of change in position, I think, that the government made from the case when it was in the district court and the Court of Appeals and now. So in the Court of Appeals, I think during oral argument, the government expressly said this is not a solicitation statute. This is different from aiding and abetting. And their position now is that although the text of the statute refers to inducing or encouraging, we should construe encouraging to mean soliciting or aiding and abetting. And I think I'm actually sympathetic in this situation to the SG in a way, because I think
I just want to note that Melissa's face had no chill.
There's
Melissa's
a
face
separate
had no-
subsection that specifically criminalizes aiding and abetting.
Yes.
So
It's
this
the very
one
next
can't
subsection,
be
in
an
fact.
aiding
It's the
and
very
abetting
next
provision.
subsection that
It would
says aiding
mean
and
that, like,
abetting.
you're
They
saying this
could
is
have
aiding and abetting, but the
twice
sympathy
in a
that I have is the slight switches in position. I think there's always a lot of criticism, like, you've changed your mind. On the other hand, it's quite common for once a case gets up into the Supreme Court, you have different attorneys, you want to make slightly different arguments, and they also say that the defendant has changed her position and she's offering new arguments in the Supreme Court. So I feel like there can be some.
Yeah,
stuff
so
going
that's
both
true.
ways.
But like on this particular example, I think it's really problematic for the government because the government's main thrust of its brief is trust us, right? Like we promise we will interpret the statute in a very limited, constrained, principled way. And then it turned out they weren't even able
literally
to
the same
adopt a
case.
unified theory throughout this particular case. Like,
Right. Our trust in them is lost.
Right.
But I mean, it is honestly, I think we should pause for a moment. Like, it's literally the next subsection of the statute that is aiding and abetting. So the idea that
And
Congress.
it's aiding and abetting any of the things that preceded.
Correct, exactly. So to suggest that this is a solicitation or aiding and abetting statute and to ask the court to rewrite the statute.
So why did the court take this?
Ostensibly.
Because this is actually
because the Ninth Circuit invalidated a federal statute
Exactly.
in the SJ petition for cert. That's why.
I mean, it feels it's and it's hard not to, in this particular political moment, it's hard not to feel like this has particular political resonance, given what it's about and the kinds of conduct that it could cover.
Also, First Amendment, there's a special, cert worthiness for First Amendment cases. There just is. There's a lot of folks on the court who are really interested in First Amendment stuff. There's a lot of law clerks who are really interested in First Amendment stuff, and I feel like it's a kind of bonus for a cert petition.
And if you would like to read the paragraph that explains why the the respondent should win on that First Amendment argument, read the first paragraph of respondent's brief. It's just
That's a
amazing.
really
Yes.
It's a chef's kiss, kind of.
It is beautiful.
So
so that's only one of the cases coming up. The other case is
Sarah,
one that
thank you so much for
Thank you
joining
all
us
so much.
about this.
Yes, thank you, Sarah. It felt so familiar to have Sarah that I just wanted to keep going.
I know.
How do you feel about administrative law?
So the next case, which Jamie will relay for all of you, is one that should be, I think, on the top of your radars. This is Salo Law
Huge case.
versus the CFPB, which is the Consumer Finance Protection Bureau.
Yeah, Consumer Financial Protection Bureau.
And a man named Paul is arguing it.
So before, I would just like to note the origins of before Elizabeth Warren killed Michael Bloomberg.
Like literally murdered him.
Repeatedly, by the way.
over and over
Elizabeth
and over
Warren
again.
knows that even when the dragon seems down, you kill the dragon again.
It's true.
Drogon. She's like. So before she killed Michael Bloomberg 11 million times, she gave birth to the CFPB. That's where I was going with
Elizabeth Warren, mother of the CFPB.
It's like the circle of life. Okay, all right.
And I have to tell you, when I was a law student at Harvard, Elizabeth Warren was my contracts professor. And I distinctly remember one day we were
Did she walk up at the front of the class and announce, here's an NDA or a provision that will release employees from NDAs if anyone ever wants to use this?
No, she did not have that opportunity. But what she did do is she came into class one day and she was talking about, I think we were talking about contracts and contracts of adhesion and toasters and things blowing up. And she told us about this idea that she had for what she called at the time, I think it was the Consumer Financial Safety Commission. And how it was, and it was like this, and she had written a law review article about it, and how it's it'll probably never come to fruition, but it's kind of a cool idea.
Keep dreaming, Liz. It's gonna happen.
Fast forward, a decade or so, and we have this case that is questioning or challenging the constitutionality of the CFPB. And so this is an appointments clause case. And for those of you who have been listening to Strict Scrutiny since the beginning, you'll know we covered another appointments clause case involving the statute PROMESA, which is about the Puerto Rican Financial Management and Oversight Board, I think.
Debt relief.
Yes, debt relief. And so that case was about the power to appoint and whether appointment provisions violated the appointments clause. This is about about the power of removal, which is an implicit power under the Appointments Clause. And so when the CFPB was initially proposed, it was intended to be a multi-member commission, but it ended up being passed as an agency with a single director to be appointed by the president and removed only for, quote, inefficiency, neglect of duty, or malfeasance. It's basically a for-cause removal provision. And the question is whether that type of removal authority is constitutional. And the kind of background principle here is that it's generally understood that the power to appoint also encompasses the power to remove. And that's because we have a 3-branch system of government. There aren't 4 branches, which means that administrative agencies need to be accountable to the executive. And the way that happens is through the power of removal. So so in this case, you have Sala Law, which is a law firm that was being investigated by the CFPB and didn't want to turn over documents. So it just challenged the constitutionality of...
It's catching.
It's what?
It's catching.
Yes.
People not wanting to turn over documents.
There you go. So just challenge the constitutionality of the agency, and you can avoid doing so for many, many years. In the Supreme Court, interestingly, the government actually conceded the unconstitutionality of this for-cause removal provision. And so right now, the government and Sala Law are on the same side, essentially, with one tweak that we'll talk about. But they have 2 basic arguments. The first argument is that for-cause removal of agency heads is presumptively unconstitutional. And they say, sure, court, you have occasionally allowed this, but only in narrow circumstances, and this case is totally different. And so the primary case the parties talk about is this case called Humphrey's Executor, which upheld for-cause removal for members of the FTC, the Federal Trade Commission. And what the petitioner says is, well, this case is totally different from that because that was a multi-member commission. And multi-member commissions have to, reach consensus, and that protects people from arbitrary decision-making. And so that's fine. But this is not that situation. The problem with that is the Supreme Court also upheld for-cause removal in a case called Morrison, which involved a single head of an administrative body. It was the Office of Special Counsel, but with a petition...
Independent counsel.
Independent counsel.
I think it's the Office of Special Counsel.
I think it's the independent counsel.
Yeah, it's the
Oh, is
independent
it?
counsel, yeah.
Okay. But so what the petitioner says about that is, well, yeah, but that office has a very narrow investigative authority. They don't look at the public generally. It's just about kind of federal personnel issues. And then there are other removal cases, but the petitioner basically says all of those are distinguishable. The court has never upheld for-cause removal of a single director agency with these massive enforcement powers who is accountable to no one. And then the second argument is, if you don't believe us that Humphrey's Executor case is distinguishable, you should overturn it. And the thing that's and this is a 90-year-old case that is basically the bedrock of the modern administrative state. And the stare decisis section of the Sala Law's brief is less than 2 pages. And of the government's brief is 1 paragraph, which I feel like says something about the state of stare
Just like
decisis.
sitting
It's for
around wearing
suckers.
stare decisis is for sucker
Exactly.
t-shirts, writing briefs.
We need to make those.
We
Strict
do.
scrutiny and stare decisis
we need
for
to do that.
suckers.
We do. Before the court starts making them for
Yeah.
So, Leah or Melissa, do you want to talk a little bit about who is trying to argue for the CFPB?
I think his name is Paul.
Most likely.
I think it might be Paul.
Exactly. It's a safe guess, this particular argument sitting. Yes, so this was a case in which Justice Kagan selected Paul Clement to argue to defend the constitutionality of the CFPB structure.
It's his first argument, right?
Yes.
First after 100. This might have actually been the move where Elena Kagan goes back to her office and strokes a hairless cat for a half an hour. It is kind of a genius move.
It is. And honestly, his brief, Paul Clement's brief, did not disappoint.
It is excellent.
It's a good brief.
Yeah. I don't even know where to start.
It has everything in it. It has exit ramps. It has responses to the stare decisis question.
It has a unifying theory of all of the Supreme Court's cases.
Like,
It's beautiful.
it's
Well done.
the platonic ideal of a brief.
It has some, let's say, kind of baller moves in the brief. First
It is the Jennifer Lopez and Hustlers dancing
Yes.
to Fiona Apple brief.
It is.
Right? It's like, I've been a bad, bad girl. It's that
So
kind of brief.
first, Paul comes out swinging in his fur coat and devotes a mere 2 paragraphs, basically, to the government's main theory in which it is using to distinguish the CFPB from Humphrey's executor. You know, the government's main theory is this is a single director agency, therefore that's completely different than Humphrey's executor. And Paul disposes of that in 2 paragraphs, signaling like what kind of utter bullshit that is, because it's just not a distinction that makes any difference whatsoever when you are thinking about the extent of presidential control. Because who is easier to control, a single member body or a multi-member body?
And
it's not hard.
He gets a Constance Wu assist from my colleagues at NYU, Rachel Barco, Kirti Datla, and Ricky Revez write this amicus brief where they're administrative law scholars, and basically their whole point is like, if you're going to rest government, government and SALA, your whole theory on this idea that multi-member boards are somehow easier to control, well, there's huge diversity in multi-member boards. They can be appointed differently. They have different kind of removal requirements. They deliberate differently. So all of that is kind of bananas. So that wouldn't be it. And then they make this really important point. Don't go down the multi-member avenue, because the real multi-member body that you definitely don't want to touch is the Federal Reserve, right? Nobody wants to touch the Fed. And they talk about all of these other cases where among the justices talk about the distinctiveness of the Federal Reserve and how they don't want to endanger it, how Brett Kavanaugh in his dissent in the other CFPB case, PHH Corp versus CFPB, which was heard by the DC Circuit in 2018, suggests that the Federal Reserve Board might be thought of as an anomaly. Like,
right.
Don't touch it.
Well, there are so many distinctions you can identify between these different agencies, and if a distinction as frankly irrelevant to the extent of presidential control as a single director versus multi-member structure can make an agency unconstitutional, then you're opening up.
You're going down that road.
Exactly, the avenue to identify all these other possible distinctions.
And nobody wants to touch the Fed because, FYI, that's a recession.
Yeah.
So one thing,
You heard it here.
What I really loved about Paul Clement's brief, it offered a very clear, cohesive theory of all of the court's cases. It says, we can divide all of the court's cases on removal into 2 categories. Number 1, the court has always overturned for-cause removal provisions the court has always said it's unconstitutional if Congress tries to allocate to someone other than the president the power to remove. So if Congress says the president can remove with consent of the Senate, no good. If Congress says, the SEC has power to remove certain individuals, no good. But aside from that, Congress can place what he calls modest restrictions on removability, and allowing the president to remove someone for inefficiency, for neglect of duty, or misfeasance is giving the president a lot of rope. So it's not that big of a deal. I would say the weakness in this argument that I see, it's very neat, it's tidy, it's pretty. The weakness is I do think it kind of ignores the bajillion cases in which the court has really emphasized the importance of removal as a check on agency authority, and it kind of glosses over that. And it also doesn't have a very big limiting principle, because it would suggest that Congress can just create any agency it wants.
You mean like the administrative state?
A little bit.
So one other thing I just want to identify in Paul's brief, and then there are many other layers of the arguments to discuss, is in addition to just dismissing with a back of his hand the government's main distinction, he also engages in some light trolling of the Chief Justice himself and the Chief Justice's opinion in Free Enterprise Fund versus Peekaboo. So he says, if it's unconstitutional to impose for-cause removal restrictions on one officer exercising executive power, imposing those restrictions on 5 officers exercising executive power would seem 5 times worse. So in Free Enterprise Fund, the court had said these 2 layers of for-cause removal restrictions, if you have an officer who is removable for cause by the president, who then can remove officers only for cause themselves, that's unconstitutional, even if a single layer of for-cause removal restrictions is constitutional. And if you line up that case with the CFPB case, the take-home is going to end up being 2 layers is greater than 1. Therefore, the PCAOB was unconstitutional. But in the CFPB, 1 is less than a few, and therefore the CFPB is also unconstitutional. So it just starts to look ridiculous.
Supreme Court math is the best. The other thing I really liked about the Clement brief, Paul's brief, is the insistence on judicial restraint, which I think he is speaking directly to the Chief Justice, not this time not trolling him, but actually speaking directly to him. And there are all of these off-ramps that he offers the court. So one is this, I mean, I guess I would call it a standing issue. He argues that the actual heart of this dispute is about the investigation of Sela and whether that investigation is proper. And that really is very attenuated to the question of whether the director of the CFPB is removable for cause or not. So he sort of suggests like the injury here seems very tenuous, and that's a problem. On a prudential basis, he suggests that even if you could satisfy Article 3 standing and this was justiciable, there would be lots of reasons to avoid taking this case up on the merits because it's kind of artificial, right? I mean, like, again, this is a dispute about an investigation, not about the structure of this agency. And he suggests, like, don't worry, there will be a better case that squarely presents the question of the constitutionality of the structure. You don't have to manufacture it with this.
Yeah, and in particular, we know the civil investigative demand that was directed towards Sela is not affected by or traceable to the removal restrictions because it was continued by the acting director who was definitely removable at will, and it's now been confirmed by the current CFPB director who is conceding that she is removable at will, and so there's all of those events suggest actually the removal restrictions is not really relevant.
Yeah, she's a Trump appointee, and she's like, I take my cues from the president, what he said.
So what Paul says is that you should wait until a case, until there's a case in which the director has actually been removed and is challenging it. And that's what kind of Humphrey's executor and all of these other cases involve. I have to say, I don't find that super compelling because I think if the argument for cause removal is that it's a kind of imposition on our liberty and that regulated entities are, there's agency capture issues and there's arbitrary decision making. So I do think, to me, it does make some sense that the individuals who are actually being regulated or, the act is being enforced against them should have the ability to challenge that structure.
Like whether you actually substantively agree with the position, I think what he's doing is giving the four liberals on the court enough grist to grind the mill and to make the Chief Justice really, either fish or cut bait. Are you an umpire, or are you up for judicial modesty or not?
And I do think that the fact that the acting director ratified this expressly, that wasn't even addressed at all in the opening brief, which I found a little surprising, I will say, because I do think, in the reply, what the petitioner, represented by Ken Chamigan, says is that this is basically not a problem at all because there's no actual doctrine that Paul Clement invokes, which is true. I mean, it's not really standing, it's not really mootness, it's a kind of prudential, this is not a good vehicle issue. It is a strange kind of doctrineless avenue, but
it's like he is driving an Uber and he's like, we can get off here, we can get off here, or we can decide this on the merits. And then there's sort of a narrow, and this is another great part of this brief, like you could decide this quite narrowly by simply removing the for cause issue and making this person removable at will. Or you can take this incredibly sweeping stare decisis is for suckers route. That's another exit ramp where we just obliterate the administrative state and Humphrey's executor, and then we drive off a cliff like Thelma and Louise.
And we haven't even gotten to severability.
Well, that was the segue.
Oh, that was the segue. Okay.
It was the cliff.
There are so many cliffs in this place, though. It's like being in Marina or Big Sur. It's like being in Big Sur in California. There's cliffs everywhere, and you can hop off anywhere you want.
And Reese Witherspoon and Nicole Kidman are in the car with Laura Dern in the back, and Zoe Kravitz.
Who are they gonna throw off a big flight of stairs?
Oh, Stellan Skarsgård. Yeah. Who's the Stellan Skarsgård?
I don't know. That's what I was asking you.
So on severability, that's the one place that the government and the petitioner are not in agreement. So what the petitioner says is, if this is unconstitutional, you should either just decide this case in reverse and not decide what impact this has on the statute as a whole, which seems unlikely, or you should declare the entire Consumer Financial Protection Act unconstitutional as a whole, every aspect of it, every prohibition, everything. And the government says this is not hard. There's a severability clause.
There was purposely a severability
Yeah, you can just get rid of for-cause removal and make the director removable at will, and the problem is gone.
But the petitioner says that, I mean, this is sort of weird. It's kind of like, the Dionne Warwick part of this brief where the petitioner tries to read Congress's mind, like what Congress really would have wanted in lieu of just getting rid of the removal for cause and putting in this removal at will is to make this a multi-member body, which you can't do because that would be too much for you, court, even though this whole stare decisis thing, that would be enough. That's too much for you to do. So instead, just get rid of the whole statute.
Which is, incidentally, exactly what the government is arguing in the Affordable Care Act case in trying to strike down the entire Affordable Care Act because Congress would not have wanted a mandateless act.
Which, by the way, Congress enacted in the Tax Cuts and Jobs Act. But again, we can't discuss this case because I would just start swearing all the time.
And we are in public, and we said we keep this PG for our children. Okay.
I kind of think that the most likely outcome is that the court says this is unconstitutional, but severability applies. Let's sever it.
Yeah, I agree.
So I thought it was interesting here that there are so many amicus briefs from members of Congress.
Yes.
Like, don't you have laws to pass? Like, why are you in legal writing?
I'm pretty sure they don't pass laws right now. They just confirm judicial appointees.
Yes. Ooh.
Sorry.
Ooh, hot burn. Okay.
I don't think they would take that as a burn. No. I think they would say, yes, exactly.
Yes, that's exactly what we're doing. So there's actually a brief from Senator Sheldon Whitehouse of Rhode Island, Richard Blumenthal of Connecticut, and Mazie Hirono of Hawaii. And they have been actually big brief writers this term. They also filed
writing some spicy takes.
They do have some spicy takes.
Yeah.
They also had spicy takes in the NYSERPA case, the gun rights case that we talked about earlier. But they filed a brief with Sussman Godfrey. Steve Sussman was the counsel of record on this one. And this is basically like a kind of law review about all the ways that they hate the unitary executive theory and how the unitary executive theory is basically the root of everything that is wrong with government today, and it is the foundation for the effort to completely undermine the administrative state and possibly take down democracy.
Yes.
I mean, I don't think I'm being
That's a
hyperbolic.
TLDR of the brief, definitely.
It's the whole thing. It's really interesting, and it's incredibly learned. They cite some really terrific scholars. It is wide ranging. It literally starts with the New Deal and keeps going. I mean, so they're covering some ground here. And they cite this piece from Gillian Metzger, her Harvard forward. She's a professor at Columbia Law School.
I love this piece.
The Harvard forward, 1930s Redux, the administrative state under siege. This is the 2017 Harvard Law Review forward. And she basically talks about the fear that the Roberts Court, she says, has gained the reputation as a pro-business court, thereby reinforcing perceptions of it as anti-regulatory, and it has become increasingly polarized. That was in 2017, and I think they're saying, like, yeah, everything she said only like 150 times
Which
more.
I think comes back to Justice Kagan's appointment of Paul Clement.
Yes.
Which is so interesting to me because I think, I don't know, if I could get in Justice Kagan's head, and I should never do that, I would imagine, maybe she still has faith that the court can come together and reach a result, and so she's going to kind of give them on a silver platter this conservative, gray-haired man who will give them arguments.
Paul.
Yes, named Paul, who will give them arguments that they can use, and all this will do, and they can reach a consensus decision, and this will shore up the legitimacy and confidence in the court.
Yeah, I don't think that's going to happen, Elena.
But keep stroking the hairless cat. I do think it was genius to appoint a conservative to defend the CFPB. Sure. I mean, it's totally a playing against type. But, I mean, we already know how at least one justice is sort of leaning because Brett Kavanaugh filed a dissent in PHH Corp, which was the DC Circuit's
I didn't catch
version
that
of this
from
case.
the 75 Kavanaugh J parentheticals after PHH citations in the briefs here. Well, there were a lot.
People were pointing it out. And so I mean, I think there's at least one person in the bag for this, probably Gorsuch as well, who has been famously skeptical of the administrative state. But I think the other thing that no one's really sort of taking into account is that this is about the CFPB, but it also has like sort of broader implications for other administrative agencies. There's currently a petition pending challenging the leadership of Fannie Mae and Freddie Mac. Those two might be relevant to those of you with student loans or people who might want to get houses at some point. So these cases will have long-term implications. So what happens here is not just about this particular agency.
Yeah, there are dozens of statutes that were modeled after Humphrey's executor, and if that is overturned, not just all of those agency structures will be at risk, but all of the decisions they have made in the last however many years could be subject to revisitation.
And on that bright note, perhaps we should move on to our next segment.
I am so excited.
We have a little ray of sunshine coming up to the stage. Please welcome BU's resident genius, Danielle Citron.
Oh my gosh, that is a lovely neck piece you have. It's like your jabot.
I am ready. And
You have to speak into the microphone.
You've got to use your microphone.
are we going ninja?
Yes.
Like,
So
so-
for listeners who won't be able to see
Yeah.
this,
Yeah.
Danielle is currently wearing a strict scrutiny bandana
Yep.
as a ninja accessory.
yes.
Well, I had it as a ninja. Like, okay, you are so giving fierce Ralph Macchio vibes. I love this. Sweep the knee, Danielle. Sweep the knee. I love that.
I'm so ready.
You look.
Right.
You were also wearing it in a kind of Hermes-esque scarf way, which I thought also worked really
I think
well.
you're just making me feel better, my friend.
You look great. You like it's a
Melissa is clearly the most fashion-forward person of,
Yeah.
I feel like, the co-host. So if she says you're good, you're good.
Am I good?
You can
Okay.
definitely do this. Dean Onawachi Willig definitely
And
get
I'm
pictures
scared.
of this for the website.
I'm totally okay.
Yeah.
Do I
look
keep
good,
my
girl.
job? That's the key, right?
So we cannot imagine
Okay.
doing this episode without also having a conversation with Danielle. And we wanted to discuss how two pieces of her tons of different kind of multifaceted work touch on the Supreme Court and Supreme Court commentary.
So, again, it bears repeating that Danielle is not just a genius regularly, but she's an acknowledged genius from the MacArthur Foundation. She is a winner of one of this year's MacArthur Genius Grants for her work on cyber civil rights. And so I am especially interested in your work on deep fake. So first of all, can you tell us, what is a deep fake?
Okay, so a deep fake is a technology that allows us to manipulate or to totally fabricate from digital whole cloth video and audio showing people do. I know you can't take me seriously. Should I take this
Take
off
it
or
off,
like
yes.
flipping everyone out? Okay. Doing and saying something that you never did or said. And the technology begins like so many things do online in the sort of recesses of the internet with porn. So in 2017, there's a subreddit devoted to deepfake sex videos. And the tools to create deepfakes are really democratized. So you go to YouTube and there are countless tutorials about how to make deepfake videos. And like so many things, I sort of feel like the canaries in the coal mine of how we abuse technology is it's often women and marginalized people. And then they go mainstream and then hostile state actors use them.
And then Michael Bloomberg just tweets it out.
And Michael Bloomberg, like, let's have a minute. Yeah. Okay. But, what we've seen is...
He came back from the dead.
He did.
To create a deep fake.
Exactly.
Himself alive.
And with deep regret from all of us. Like, dude, don't go into the deep fake business. It is not working for you. Right. But so of the 15,000 deep fake videos online, 96% are deep fake sex videos, and 99% are of women's faces inserted into porn without their consent. And it's true. So many folks, when we talk about deep fake, say, Danielle and my co-author, Bobby Chesney, you're sort of blowing things out of proportion. And I think, our feeling was, A, we're not blowing it out of proportion because there's a tremendous amount of harm in the here and the now to largely women and women of color and trans women, folks who have been inserted into porn without their permission, and often with their names attached, their home addresses. There are sites that their entire business model is online advertising for the encouragement of user-generated content, user-generated deepfake sex videos. So there's harm in the here and the now. And there's harm in the here and the now in a way that involves state actors, because we saw with Rana Ayub, an extraordinary journalist in India whose work exposed the corruption of the Hindu nationalist government. And she's a Muslim woman, and she was targeted a year and a half ago with a deepfake sex video. So it showed her engaging in a sex act in which she never engaged in. And within 48 hours, it was wildfire. It was on half of the phones in India, spread via WhatsApp, Facebook, Twitter. Her Twitter feed, her email inbox, her texts were all overwhelmed with death and rape threats.
And it was all intended to silence her critiques of the Modi government.
And it achieved its result for a good 6 months. Even the UN Council on Human Rights issued a statement saying, we're afraid for her safety. So it wasn't like she was making it up, right?
So, I mean, again, we are totally sympathetic to this claim that you are being hyperbolic and calling things out. We have said before, we constantly feel like we are Cassandra, destined to know the truth and not be believed.
That's just another.
And let's have a moment. The best Cassandras I know, God bless, love you guys. As I listen every week or more to Strict Scrutiny, I think I've got my sisters. I'm good. Yeah, here we are.
It does feel like, because often the victims are women or women of color or marginalized people, you can sort of miss the really broader implications of this and how this is really not just disruptive to personal lives, but could be disruptive on a broader level. And one of the things that you and Bobby Chesney highlight in your California Law Review article,
Just came
put
out.
that out here, just came out, hot off the presses. Download it while it's hot. You note that this really has important consequences for democratic institutions, government, the economy. Like, imagine on the eve of Snapchat's IPO, there was a deep fake of, the CEO doing something totally terrible or questionable. That would have been harmful for the initial public offering. Or imagine, more particularly, the eve of the 2020 election, the famous October surprise. What if the October surprise is a video of one of the candidates doing something that she never said?
Right, or gravely ill, right? And so people, undermine the process because they don't go to vote.
Yeah.
And so fundamental to all of this is just the decay of our trust in the integrity of elections, as well as much as Bobby and I really worry about people believing fakes.
Yeah.
We're also deeply worried that not only that we'll start to disbelieve the truth.
This is the liar's dividend.
Yeah.
I love this line.
Yeah,
I love
right.
it. So what's the liar's dividend is basically we become so skeptical of deepfakes that when we are actually, and the reason why we believe deepfakes is because we are conditioned to believe what we see.
Absolutely. And that's, video and audio, what's different. Lies are nothing new. So when we started working on this project about 2 years ago, folks said, calm down. It's a lie.
Cassandra,
girl, we've had a lot of lies
Chill,
before.
girl.
Chill out, lady. Stop flipping out. Right. And our response was deepfakes are different because we have this visceral response to audio and video. And in particular, we have a visceral response as well, and a tendency to believe video and audio that confirm our beliefs, and that's salacious. And couple that with the business model of platforms, that entire reason for being is likes, clicks, and shares. And we're going to click, and share and earn advertising income from the salacious, visceral grabbing deepfake.
So not only then are we more inclined to believe the deepfake, because when we then start becoming skeptical of deepfakes, when we start being educated about the prospect of deepfakes, it also makes us more skeptical of things that might actually be true. So imagine, for example, you had a presidential candidate saying that he could grab women by their private parts because he was a star.
Imagine.
Imagine if that happened.
And they just let him do it.
And they let him do it because he's a star. You might be inclined to disbelieve that as a deep fake because you are recognizing that these deep fakes happen. So this is the liar's dividend.
And wait, ready? And our guy, he capitalized
It was hypothetical.
This hypothetical guy capitalized on this possibility by about a year after the hypothetical tape comes out, says, that was a totally doctored audio. Never happened. And that interview with Lester Holt in which I say that, Russia is why I fired Comey, that didn't happen.
That was a deep fake too.
That was a deep fake.
That's the liar's dividend.
That's the liar's dividend. Like using our skepticism, education about deep fakes to escape accountability for wrongdoing.
Right. So can I pivot?
Yeah.
That sort of deep fakes, video, audio that can disrupt democracy, disrupt democratic institutions. How do deep fakes impact SCOTUS?
Okay, so, Jamie, we were slightly talking about this. So, we have seen video and audio be taken as total truth by the Supreme Court, right? In the Scott versus Harris case. We're my Civ Pro kids. I see. Well, yeah, woohoo!
I just want to note for the audience, who's not the people listening at home, these are incredibly glowy, happy Boston University law students.
I love my
They
students.
look tan, they look rested, well fed. Like, you guys are doing something great here.
The cutest and the smartest.
Definitely.
Gotta say. Okay. So in Scott versus Harris, right, the Supreme Court is presented with a question on summary judgment if the court can basically look at a video of a man driving incredibly fast away from the police and say the video basically speaks for itself.
Yep.
That is, there's one way to look at the video, and there were no signs that the video had been doctored. But it is this powerful sense that when we see something, we can, of course, believe what we see and hear. And so that's the power of the video. So that's, I guess we could make up some good SCOTUS. Have we thought of some good
Some
ones
of
that
our
we can
listeners
make up?
have. So, for example,
tell us.
the Chief Justice, all of his pictures in the impeachment trial. One of our most wonderful listeners, Adam Music, photoshopped some strict scrutiny swag onto the
Wasn't there a
Chief
coffee
Justice.
cup, right? Like a strict scrutiny coffee cup?
Exactly.
Like
He had a
drinking
coffee
out of?
cup.
Yeah.
He had a baseball cap.
Oh, yeah.
My dog, Stevie Nicks, was sitting right next to him in her Enforcing the Voting Rights Act bandana.
Did he have this?
Well, she was wearing a slightly different bandana.
Okay.
So,
Well, so what I love about this is you talk about, the First Amendment implications of the discussion of deep fakes because parody and satire are a really important, critical First Amendment protected activity.
Yep.
And in situations like the, Chief Justice, it is obvious what's happening, right? Nobody thinks he's sitting there with a trucker hat on.
He really had that.
But some of them, it's not always as easy to see. And one thing I loved about the Scott versus Harris case is there's this footnote that says something like, there's no sign that this was doctored. And I'm just imagining you've got, an octogenarian who still gets excited about a fax machine.
I don't know who you're talking about.
Thinking that he'd be able to kind of like discern facially whether a video is doctored or not. And
it's like obscenity. You know it when you see it.
Totally. And what's even scarier, I love freaking everyone out. Sorry, I feel like every time I give a talk, we walk away depressed. And we'll say something to make everyone feel better before we leave. But no, we won't.
I don't have any
we
advice
won't.
for that, to be
I
clear.
listen to them
Pretty
religiously all the time. We're going to walk out depressed, but feeling like we learned from the smartest minds. Okay. So right now, the technology is such that technologists explain that at least for audio deepfakes, they can't, as a technical matter, tell the difference between what's real and what's fake. The sophistication of generative adversarial network algorithms are so sophisticated that, and they suspect that within at least like 6 to 9 months, that the video will be so refined that technologists like Hani Farid, who I do a lot of work with at Berkeley, explains that at the arms race we are as the technologists building these systems, we're going to lose it. We're going to be behind, if you think of black hats and white hats and gray hats, that the manufacturers of deep fakes, they're going to win the game in the deception, right? So it doesn't mean that journalists can't do on the ground work and figure out, were you there? Did you say what you said? That's what journalism, beautiful, wonderful journalism does. But it's in the moment, especially in social media environments, when a video goes viral, and you can't detect, just technically speaking, if something is real or fake, and it goes viral, as you said so well, it's going to tip the election. It'll, slam the IPO, and there's some things you can't take back.
It can move markets.
Absolutely. Right.
So it seems like the deepfake threat at SCOTUS is actually exacerbating an existing threat that a number of people have pointed out. And this would be a good point to note that women know law too. So we'll pass these out later. This is a group that at the University of Michigan, Women Know Law, encouraging us to cite more women scholars. And so I will do that. Yes. Allison Orr Larson, who is a professor at William and Mary, has talked about the degree to which the court almost slavishly relies upon extrajudicial facts that are introduced not from the record, but through amicus briefs. And she notes that that is totally problematic because when they are introduced through amicus briefs, they haven't gone through the process of being vetted. There's no Daubert kind of clearance. They aren't subject to cross-examination. They're just sort of presented in amicus briefs. And, most of the time people recognize as amicus curiae that they have this obligation as a friend of the court to provide truthful information, but you may not actually know the true veracity of your facts, and the court really relies on this. Another issue, again, women know law. My colleague at NYU, Nancy Morowitz, in a case, it was an immigration case called Enkin versus Holder, and she noted that the Solicitor General's office, in defending their immigration decision, relied on these factual assertions that they had from insider sources about how the immigration process worked from the inside. And they made this claim that if someone was deported and then subsequently won their appeal, that the government facilitated bringing them back from whatever country they were deported to. And she's like, how the hell do you know that? Like, how do you know that? How can you prove that? And so she went and filed all of these FOIA requests, show me how you know that. And the Solicitor General's office was actually forced to issue a correction to the court that they had misstated that particular claim. And she prevailed in that case, but she noted that the damage had already been done. It had already been introduced into the record and relied upon in the deliberation.
And that's not the only time that has happened, by the way. Like, this has happened in other immigration cases, including the extent of the government's detention authority and Zavidas, like the statistics that the government presented there and that, later became relevant in Jennings versus Rodriguez, turned out not to be quite right. So
in Korematsu, there was, information that was provided that was, later acting Solicitor General Neil Katyal issued a public apology about it. And I think going back to the amicus part, what it felt like a parallel to me is that nowadays, in many cases, there are dozens and dozens of amicus briefs, even just for a single individual case. And there's just no ability to be able to kind of vet or evaluate every single thing that's in those, much like the speed with which videos kind of go through and how much we're seeing every single day. We don't have the capacity to evaluate that. And it creates, real opportunities to mislead people.
It's interesting thinking about the Brandeis brief and its innovation for the court, right?
Also full of misleading statements.
Totally, right? And no doubt. And how we've seen it develop with these amicus briefs that are taken on faith and so often cited, right, for factual propositions. I know in the privacy community,
like abortion, Justice Kennedy, and like Operation Outcry, like women suffer abortion regret,
who made that up? Right? Yeah.
It's sort of thin evidence,
right?
And
contested,
relied upon,
and right. That's and then integrated into the record.
And it makes you wonder how. I would hope that lawyers wouldn't be presenting, actual like deep fakes or even what's the lighter version of deep fake? Cheap fake.
Shallow or cheap fake.
Yeah, cheap fakes.
Yeah, just
but
distorted video. Yeah.
But yeah, these sort of stuff gets propagated. Like the statistic that the court keeps repeating about sex offenders being likely to, reoffend more. Turns out that's not true, right? And the court keeps saying this because they said it originally, and it just gets repeated as if it were true.
And amicus briefs often cite, websites. Someone says something on a blog post without necessarily vetting that either. So
Yeah. It does sort of show you're in this age of disinformation, and its grip on all of us. And we often think of, legal institutions and especially the courts as being the guardians of the gate against deception and disinformation and propaganda. And it's worrying us, huh?
One last thing I kind of wanted to note is that, you started by talking about the particular impact of this on women, and particularly women of color. And I think it intersects with something we talk about a lot, which is, professionals, women professionals. There have been a lot of studies done, and I've written on this, I know you've written on this, about the way that professional women across, all different kinds of professions are treated on social media. And I just wanted to highlight one study that was done by the Center for Strategic and International Studies, which found that 42% of women parliamentarians had extremely humiliating or sexually charged images of themselves spread through social media. These deep fakes, 42%. I mean, that's shocking. And in a time where we need to encourage women to run for office, to put themselves forward to become judges, that's horrifying.
And think about Katie Hill, right? Katie Hill, the photos that were taken in confidence and in a consensual relationship with her spouse and girlfriend, she basically is chased out of Congress. And it does send an incredibly powerful message.
It's stay in your
to
lane.
Women. Yes, don't bother.
See, here's the thing,
right?
though. I'm not staying in my lane.
Yeah. I think this group is, we ain't. Yeah, forget
I'm not
it.
staying in our lane.
No.
Cheers to that. This is water, I promise.
My lane is a highway, bitch. Like, my lane is a highway. Right?
In life, what's that movie, Hallie Met Sally? You say, I want to have what she's having. Who in the audience wants to have what Melissa's having?
Me.
I think in life, I want to be in your lane too.
No, I think it's really
Moment of appreciation.
I mean, we're all on social media. I think I got tweeted at today by a former student. This is the same student, I think, who used to follow me to the bathroom to ask questions when I was grossly pregnant while teaching. I was
leave me alone.
and he would wait for me afterwards to continue asking questions. And so it was the same kind of thing. And I'm it's sort of just
yeah.
is it truly a question? Is it a questioning of authority? Is it I'm being called on the carpet? And I'm just I'm just kind of tired of it.
Totally.
I'm tired of staying in your lane. I've got my own lane. I've got things I want to do. My lane is the highway, and that's what I'm driving on. And
I love it.
yeah, and so thank you for telling us about these deep fakes so that we can all be aware of them, be aware of the liar's dividend, think about the way that disinformation not only impacts elections and IPOs, but actually may impact the way that the Supreme Court thinks about cases. So
And
thank
that we
you.
can think twice about the things that we retweet and make sure that we kind of...
I haven't
we gotta
retweeted
stop
anything
thinking,
today
Lisa.
for that reason. I've been incredibly not my lane is one of pure information. And I haven't retweeted anything today.
Totally. Yeah, we're the bug in the code in so many ways, right? We are the ones sharing, right? It's our sort of human weaknesses and pathologies that we can, what information that confirms our biases, we send it on. We feel comfortable especially if it's negative or novel. We are passing that around. We love the provocative, and we live in filter bubbles. So to the extent that we can talk to ourselves and talk to our loved ones and say, hold on, before you tweet, think about it. Mm-hmm. Read what it is you're tweeting about, don't just tweet it out. And also have real conversations with ourselves about the kind of public sphere and public life we're creating.
I've just thought about what my public life is. My public life is an odd amalgam of SCOTUS tweets and Meghan Markle content.
Love it. And
here for
theory.
it.
It's amazing content.
On that note, we have been so delighted to be here at Boston University. Thank you, Dean Onwuachi Willig.
Yeah.
Woo! So can I brag a little bit about your dean? You guys have
Yes.
the best dean.
Yes.
Again, full stop. Angela Onwuachi Willig has been my sister-in-law since 2006. I hired her at Berkeley, raising the number of Black women by 100% at that school. And we are so excited to see all the great things that you're doing here at BU. Thank you for having us here. Thank you for lending us your fantastic colleagues, Sara and Danielle, for this conversation. We have been so delighted to be here. You have an amazing WBUR team here who have done everything to make this whole taping so seamless.
We are so
thank
spoiled
you.
right now.
We're so spoiled. Like, you guys were the just best hosts. Thank you so much for having us. This was an absolute delight, and it was just wonderful.
Can I bust in just for 1 second?
Yes.
To brag about Leah for a minute?
Yes.
So Leah Litman, sort of rock star constitutional law thinker, I met, and she edited 2 of my pieces when she was editor-in-chief of the Michigan Law Review. And I got to meet Leah 11 or 12 years ago. I came to campus. And meeting her, having had the incredible joy of having her insights and the best comments I've gotten, forget colleagues, just from anyone. I said to Leah, we took a walk, and I was like, you need to be an academic now. You need to teach all of us immediately. And it has been such a joy, not only to be your friend, but to watch you just take off like a rocket ship and teach all of us. And I always feel so grateful knowing you as I have for 12 years, and I'm so proud.
So can I pile on?
Yeah, please, let's pile on.
I'm gonna pile
Leah,
on. I'm
I
gonna
love
pile
you.
on. Okay,
You rock.
for those of you
Poor
who
Leah,
are
her face
listening
is
at
so red
home,
right now.
Leah's face not only has no chill, it's
Yeah, you
red.
have no type of chill.
No chill.
no
no
chill,
type of
totally
chill.
red. I think I just learned
Leah's
this
gonna make
year.
Melody delete this part.
No, we're
No,
gonna keep
no.
it. We're keeping
no,
it. in.
No.
I think I just learned this year that Leah is untenured. Like, I mean,
How is that a thing?
how is that a thing?
How is that a thing? I'm giving it to her right now.
Like,
I'm calling
a
her
genius says
Michigan.
it,
Like,
it
we
happens.
got this.
you got strict scrutiny tenure.
This is why I love my dean.
Okay,
Yes.
so for those of you who are listening at home, Dean Onawachi-Willig just made a unilateral
Yes.
appointment. Leah
Don't
will
worry,
be
we gotta keep it
removable,
front pond,
removable only
right?
for cause.
Inefficiency, and she's not going to be inefficient.
Malfeasance,
No
none
way.
of that.
No
She's gonna be here
neglective
forever.
duty, not a chance.
So Leah started strict scrutiny. Like, she brought all of us together. She is literally the wind beneath our wings and keeps us going and does all the twittering. And,
And
she's-
like, girl, who's doing this? But holy
you gotta speak into.
Sorry. I don't wear the ninja strict scrutiny bandana for anyone but you. Just saying. Like, I will literally do it all. Okay.
You are all the best, and like, the reason why there are more women who want to be law professors and lawyers, and like the reason why there are women like me who are willing to be extremely loud lawyers and law professors, is because we have models in you, and because like you all like gave me encouragement. And like, I remember, Melissa, I think I like got to know you because I was just like tweeting at you and like emailing you how awesome you were when I like saw you like testifying before Congress, and I was like, I want to be her friend, she's so cool. And but just having this support group of women who are fabulous and not afraid to be themselves has been the best thing that could happen for anyone professionally or personally. And while things can seem really dark and bleak and hopeless, having, just sometimes maybe, having this group of women who are willing to support one another and just keep propping each other up is, I just hope everyone can find that.
On that note, thank you, BU. We have lots of people to thank, not just you for your tremendous hospitality, but also Melody Rowell, our terrific producer, Eddie Cooper, who does our haunting intro music, and of course, everyone who helps us get this into your ear holes. If you like what you hear, if you love supporting feisty women who are staying in their own lane/highway, you can support Strict Scrutiny by going to our website, www.strict www.strictscrutinypodcast.com, where you can find all kinds of Strict Scrutiny merchandise, including the ninja bandana, as discussed tonight, sweatshirts, trucker caps, tricolor tees, all kinds of cool stuff. Some of it worn in deep fake photos of the Chief Justice.
True.
And you can also support the pod by subscribing through our Glow campaign. So that is glow.fm/strict scrutiny. So thank you all for your support. Please keep your reader reviews coming and let us know what you'd like to hear from us and tweet at us. You can follow us at @strictscrutiny_ on Twitter. Thank you.
One, I promise I will want to delete that section with compliments. Two, we went a little bit long because we love Sara and Danielle, and honestly, I would just stay talking to them all night. But we do, I think, have some time for audience questions. I think Alex from WBUR and someone else might have a microphone, and because we can't necessarily see the audience with
No,
the
we can.
lights, okay,
a little bit.
well, Melissa, then you can call on people, or Sara can call on people if anyone has
I'm
questions.
going to be like Paul. 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 And we have gifts too. Like if you want to ask a question, you'll get something.
It better be a good question, though.
Hi. Thank you for coming. I don't actually go to BU, but I am in law school. And in terms of back at the very beginning when we were talking about clerkships, it is, I guess, good knowledge for people to have. Like, our career services says we don't send women to do these clerkships because, like, these judges are notorious, things like that. But I think I disagree that maybe people will just stop going to that judge because clerkships are so prestigious. And so if everyone knows, like, in the cases that it is more broadly known, like, shouldn't there be more, like, what is the process once the school knows, okay, we stop sending our students or our female students, but then what?
Yeah, I mean, I would say I find it, I'll say three things and I'll try to be brief. Number one, I find it extraordinarily problematic to not send female law students and to only send men to particular judges, because then you, especially when those judges are feeders, it's just exacerbating the gender disparities among Supreme Court clerks, among Supreme Court advocates. So that is not okay with me.
No, harassment denies women equal opportunity.
Yes.
So formally denying them equal opportunity, not a solution.
Not
to
a remedy.
harassment.
Discrimination is not a remedy to harassment, as it turns out. My second comment is, I think that a lot of people have talked about disclosure, and, we provide disclosure to students. For me, that is not enough. I think disclosure to people who are in a position that really lacks power is what should be happening is that law schools and law professors should be creating mechanisms through which they can work with the federal judiciary and with state judiciaries to stop the harassment and abuse from happening, not to just make sure people know about it and then funnel particular students who won't be offended by that behavior to those judges. So that is where I would like to see things happen. That's where I would like to see movement. But what it requires is law schools and law professors and the judiciary to have frank conversations and create systems through which schools won't feel concern about retaliation themselves, because they're understandably worried about their students having clerkship opportunities.
I think that's actually been the biggest impediment for law schools and law professors is the fear that if you speak out about a particular judge in a very voluble way, you will be ruining it, not just maybe with that judge, but perhaps for his or her colleagues. And again, I guess I come back to, I don't know that it's fair to put all of this just on law professors and law schools. Like, the judiciary writ large has turned a blind eye to a lot of this. So, I mean, it's great now to say law professors and law schools should work with the judiciary, but I mean, there has to be a structure with which to work in the first place,
Yeah.
and there just isn't.
Yeah, and for example, refusing to testify at a hearing on harassment in the courts, when the representative of the administrative office and, the head of the working group does that, not a great sign. So, extending some of the anti-discrimination statutory protections, that is something that some of the groups who are organizing for change are pushing for. I think that would be a helpful step, particularly anti-retaliation provisions and other safeguards, and developing, more specific reporting mechanisms within the courts. I think that those would be helpful. But yes, like we we don't have any great solutions right now. I think that doing climate surveys and helping make this information more public than it currently is would be a great step, but that is not going to be sufficient itself.
I mean, I think the way that we have been trying to deal with this for a long time is like to create a whisper network that works in the same way that the Whisper Network works. Right. So, I mean, like, you know, clerkship offices will compile data and they'll tell you, like, well, there's this. But, I mean, as Jaime said, it's really hard to say to your hard-driving, ambitious, deserving female law student, hey, there's this really great feeder judge who will definitely get you looked at by SCOTUS, but you should not go. And like, we've all said that, but I mean, you feel like crap doing it because that just means the avenues for her are narrowed.
Hi. So I have a related question. I deeply appreciate the point that you made, Professor Murray, that the judiciary holds like deep responsibility for this problem. And one solution is that SCOTUS should stop accepting people from these judges, and people should sort of treat the judges who we all know are harassing students differently. But since none of us can sort of call up anybody on the Supreme Court and ask them to like cut it out and stop hiring people from Judge Kaczynski, I'm wondering what you think about the role of schools and professors in helping carry that concern and advocacy to these stakeholders that we don't have access to. You know, the sort of discourse around this has suggested to me that I, as a 1L, was warned by multiple women about Judge Reinhardt, and it seems like nobody who is sort of powerful and in a position to know, everyone has sort of disclaimed that knowledge, right? And I believe that is true of most people, but it can't be true of everyone. And so I'm sort of wondering, like, even if that is the case, like, it seems like these systems are very broken. So how do we try to make sure that we're, as students, not the ones who are trying to advance this change? Like, how do we call on law schools and faculty to bear some of this burden?
So that's part of what I was alluding to earlier when we were discussing, like, I can't imagine a law student or a clerk going to a Supreme Court justice and saying, like, you can't stop, or you have to stop hiring judges or clerks from this judge because they're a harasser. And so that's part of why I think, like, the climate survey is really helpful, because to the extent there is an information barrier or an information gap between law students and some number of professors, communicating information between students and the school would be a really helpful way to get information to people who are in a position to communicate that to the justices and the court and say, look, we have received information that this judge treats their clerks extremely poorly. You can, make that clerkship less attractive and put less pressures on individuals to apply there and professors to encourage their students to apply there, because you can stop this behavior. And so that's part of why I think, like, information gathering and schools doing climate surveys is really important, because I do take the point that not all professors know this information, and some professors who don't know this information might be in a position to do something. But I also, totally agree that it can't be true that nobody knows this.
Well, and I think it has been the case, I think, in most law school career services office, like, you collect this information. People do surveys, like this was the case at Berkeley. We collected surveys from clerks as they were exiting their clerkships. That is the case at NYU. And, like, that stuff is made available and shared at Yale. One of the law journals did all of that. But here's the other thing, right? It's not like the colleagues of that particular judge don't know that he or she is terrible. Like, of course they do. I mean, I think one of the reasons why this breaks down, and maybe I think like this because, like Professor Silba, I teach family law, these chambers function like families in all of the great ways that families function and in all of the totally dysfunctional ways that families function. In the same way, this judge next door knows that chambers is totally dysfunctional. They would never say anything to their colleague about it, much the same way you can hear your neighbor screaming at her kid, but you would never go down the hall to say something about it. And so I think one of the things that has to happen is we have to stop thinking about these jobs in a family-like way. I mean, like, there's something lovely about being part of a clerkship family if your clerkship family is functional. And then there's something terrible and terrifying if it's actually not.
Well, and also that metaphor just seems to cover like all sorts of
sorts of
problematic conduct, because describing these relationships as so important, right, is pushing a message to clerks that this relationship is important. Therefore, you have to be willing to tolerate some amount of behavior you experience as part of it.
Like in the same way you would never disavow your parents, you could never disavow your judge.
Right. You can't disavow your judge. And it communicates this message that there is this like network of people who like want to kind of keep things among themselves. And yes, like we need to revisit our relationship and like perspective about clerkships, even though I agree they are or can be professionally valuable. And I really do not want to get to a point where we have to say, you know, we need to revisit clerkships, period, or clerkships in general, because they are so rife for abuse. And so it would be nice if we could revisit some of what we are saying about clerkships or some of how clerkships work, so we don't have to take that more drastic step.
Hi, thank you so much for coming to Boston. I really appreciate it. I wanted to, very excited to be talking to you, especially Leah, who I followed on Twitter for a few years now, and Melody Rowell as well. I follow her on Twitter. But sort
The
of
rest of us are feeling a little left out.
well, I follow you on Twitter more recently, but them for a few years now.
Okay, you're Johnny come lately. It's cool. It's cool.
Anyway, but to that end, I was wondering, do you think that the theory of the unitary executive is necessary to enforce the Voting Rights Act?
Undoubtedly.
Yes, only because everything is necessary to enforce the Voting Rights Act. If adding a citizenship question to the census is necessary to enforce the Voting Rights Act, as, let's say, at least 4 Supreme Court justices said it was.
Is pardoning Roger Stone necessary to enforce the Voting Rights Act?
You know it. You know it. I mean, Roger Stone is a civil rights warrior. How can you imagine enforcing the Voting Rights Act if he is in prison? Come on.
Roger Stone is a victim of lynching. That's what he said. Like, that's,
I just want to be clear that,
he said that.
Melissa said that.
Yes. I'm just saying, he said that on TV. It's like he said this was a lynching.
Right, you're right.
I know
Okay,
I'm right.
Roger
I carry
Stone said it.
receipts. I'm a black woman with receipts.
Yeah.
I love your shirt, Johnny Come Lately. I love it. It's fantastic. He's wearing a shirt that has all the female Supreme Court justices. There are only 4. It's just a shirt. It's not like a gown. Like,
we're going to make a nice Supreme Court shirt with all of the men named Paul who have argued at the court
like
recently.
Natalie Portman did when she went to the Oscars.
Exactly,
like
with all the female directors embroidered on the coat who weren't nominated.
Paul. Jonathan. It's going to be lit. We're going to put that on the merchandise page.
So I think it looks like we're out of time. Sorry, we were just, again, so excited to talk to your fabulous faculty that we went a little bit long, but we will stay here to mill. We have some strict scrutiny stickers, as well as some Women Also Know Law stickers that we would love to distribute. So thank you again so much for being one of the hosts.
Thanks so much, Boston. I feel like it should be... Okay.